Honorable, the Supreme Court.
All right, thank you all. Thanks very much. Please be seated. And when you're ready, please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled John Echeverria and Karen Pratt v. Town of Tunbridge, case number 25AP244. Representing the appellants, John Echeverria and Karen Pratt, is attorney Jeffrey Vitt. Representing the appellee, Town of Tunbridge, is attorney Stephen Codius. Seated at counsel table with attorney Stephen Codius is attorney Michael John Tarrant.
Thanks very much, and good morning, counsel. Thanks for your patience. Appreciate it. And we'll hear from the attorney for the appellant first. Of course, please, for the record, introduce yourself and your client.
Thank you. Good morning. May it please the court. My name is Jeffrey Vitt. I represent the plaintiffs in the trial court, John Echeverria and Karen Pratt.
Thank you.
This case turns on the language of Title 19. I will begin there and then turn to the town's position that it has authority based on the common law to maintain trails. The language and the history of Title 19 demonstrate the intent of the legislature that towns not have the authority to maintain and repair legal trails.
But do they have the authority to create legal trails?
They have to create them?
Yeah.
Yes, they can certainly, yes, they can create a trail, but they can't build one, but they could say, look, this used to be a highway, we're going to make it a trail, which is what happened here.
Okay. So they have the right to have a legal trail or a public trail, but then there's no way to maintain it even for just foot traffic?
It has, this trail in particular has been maintained for years, perfectly fine. And the landowner has maintained the trail. A lot of the trails don't get maintained, but if we're talking about real maintenance, and frankly, what we're talking about in this case is not so much maintenance as it is improvement. This trail is fine for walking. You can use for snowshoeing. There are any number of things you can do. What you cannot do on this trail is have intensive bike use because of the effects of that.
Intensive bike use? Is that different than just bike use?
Well, look, if it were one bike occasionally, fine, but the reality is the bike lobby, for lack of a better term, has decided it wants to use this trail, which I can understand it's apparently convenient. It leads them to some other trails. But if there were anything approaching intense use, the wetlands, the nature of this trail would change. There'd be damage to it. But it has been maintained properly for years. I mean, there was no
By your
complaint.
clients, correct? By your clients?
I'm sorry, say
Your
again.
clients, the ones who maintained it.
Yes, they did.
Right, but it's your position that that's a voluntary act on their part. They don't have to do that.
Well, they don't have to. Look, a lot of the trails in town aren't maintained at all. I mean, the town in 40 years has done nothing to maintain the trails, zero.
So if a tree falls across the trail, they don't have to remove it, just leave it there.
They don't.
Same thing with the next one and the next one, and the next.
I mean, the plaintiffs did. I mean, if a tree fell, they would go out and, either do it themselves or bring somebody else in and get it off there.
But if they decided not to, that's it.
That's okay too.
But if they put a tree, if your clients put a tree or rocks or something on the trail, a purposeful obstruction, the town would have the right to come remove that and recoup the costs of damage or repair, correct? Under the
I-
plain language of the statute.
I believe, yes, if the clients did something to deliberately obstruct the trail, the town could say, wait a minute, we're going to send somebody out there and you'll be responsible.
So they have the right to repair, but only if the obstruction or the overgrowth is intentional, not if it just happens naturally. That's the way the statute is framed.
The way the statute reads, I mean, look, there was a time that towns had the explicit authority to maintain public trails. That authority was removed. The legislature made a decision in 1986 to remove that authority.
Well, was it authority they removed or the responsibility that they removed?
I think they removed the authority. I mean, they had authority under the statute to maintain, the definition gave them the right to maintain trails. Seems like there was, it was part of a class 4 road. Trails used to be part of class 4 roads. When that was changed, when the definition was changed, the authority was lost. They no longer had the authority to do that.
Mr. Vitt, would you agree that the difference between a class 4 road and a public trail is the requirement to maintain it?
I'm sorry, I didn't,
Is the requirement to maintain it. The difference between a class 4 road in a town or a village and a public trail is that the town is obligated to maintain the class 4 road to some degree.
they had the discretionary authority to maintain it. I mean, there's obligations there under certain circumstances, you know, they had to, but with a trail, no obligation to maintain it.
And can they delegate the obligation to maintain it? Such as the Vermont Snow, the vast trail system.
Could they delegate it?
I mean, vast trails are all delegated, are they not?
I don't know the answer to that.
Okay.
I don't think it's in the record, and I
No, I mean, I think that's a statewide system that people take care of those trails, so allow snow machines to.
I know that the vast snowmobile group cooperates with the plaintiffs. Their land is open to them. They manage to cooperate and keep it operating just fine. Those are not legal trails, but there's a trail system that the vast system uses, but those are not legal trails. In 1986, the legislature limited town trail maintenance authority by changing the definition of class 4 roads to exclude trails, with the result that section 310 conferred discretionary maintenance authority over highways, but no longer, excuse me, but no longer over trails. The combination of the fact that a plain reading of the current statutory language shows that the legislature terminated and intended that the towns not have authority to maintain and repair legal trails. Excuse me, I'm sorry. The absence of town trail maintenance authority is supported by other extensive differences between trails and highways. Sorry. Title 19 not only includes no provision granting towns authority to maintain trails, it also includes no provision authorizing towns to construct trails.
You want some water? We can get you some water.
I've got some here. I
Have you
apologize.
got it? Okay.
How is this going to be different after April 1st of next year?
Sorry, say again.
How is this going to be different after April 1st of this coming year?
Well, they would have, when the statute becomes effective, that authority will, the towns will have authority.
So they can go out, if there's a tree that falls over now and is across the trail, they can't do anything, but on April 1st, they can go cut it up and take it away.
But there are constitutional issues, I think, that apply, or that could apply, or that could arise by reason of this change. I mean, if the right to maintain the trails was part of the bundle of sticks that the landowner had, and the state has said, no, 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 we're going to change that. We're going to take that bundle of stick. That's a constitutional taking. And, you know, I'm not saying what will necessarily happen here, but that, I think, is the issue that the legislature worried about. And the Legislative Council, in fact, felt that there would be a possible constitutional taking if that proceeds in that way.
But a trail is defined as a public right of way. Doesn't the owner or user of a public right of way also have the right to maintain it for the, that reasonable intended use?
No.
No, that's not the
I
case.
mean,
under
there's no
easement
common law
law?
right that we're aware of. There's no statute. I mean, it just, I don't,
So if I'm granted an easement by my neighbor, and then the neighbor puts all kinds of blockages in it, I can't maintain that?
yeah, if you
That
enter
right of
into,
way?
if you enter into an agreement, absolutely.
Well, but that's a right of way. What's the difference? So if the town has a public right of way for the use of all the public and its citizens, folks that live in the town, they can't ensure that that right of way can be used and is usable by those folks?
There's no, excuse me, I'm sorry. There is no right that arises by reason of it's a public right of way. There's no common law right. If there's an agreement, I mean, if you enter into some agreement with your neighbor, sure. But the fact
So
that.
you disagree that that's even exists in the common law?
I'm
You
sorry.
argue that common law was displaced by statute, but you now even don't recognize that that existed as part of common law, that the right to maintain a public right of way?
I don't think there's any common law right. That there is no common law right to maintain that.
So it's limited to right of use. You have a right to use it, but you can't maintain it.
Yes, I mean, there is not a common law right to maintain the right of way unless it's somehow granted, but we haven't found any common law, any case that says that. Thank you.
Okay, thank you. So we'll hear from counsel for the appellee, please. Come on up. And before you start, please introduce yourself and your client.
Thank you, Your Honors. And may it please the court, Stephen Codius for the town of Tunbridge. I want to address several of counsel's points, but first I want to go right to the facts of this case. Early on in counsel's argument, he mentioned issues about types of uses that are allowed on the trails and types of uses that plaintiffs would prefer to occur there. This case is actually not about maintenance at all. Maintenance is being used as a proxy to determine who has the right to control uses on trails. And the plaintiffs have repeatedly said in this case that we alone have the power to maintain the section of trail crossing our land, and we will only do so if the town prohibits bicycle use. And yet, we know that the legislature has already said clearly, 19 BSA 304A5, that towns have the authority to make regulations regarding the use of trails. So plaintiff's argument is that Title 19 calls for communication and collaboration among town officials and landowners and any interested parties. And yet the facts of this very case undermine the reality of that argument. In the record here.
Couldn't the use of bicycles increase the use of the public trail? I mean, it could make it wider, it could make it more accessible, it could open it up to more use?
The plaintiffs have conceded that the town has the right to allow whatever uses it wants to, consistent with the purposes for which trails are created, recreation and access to adjacent properties. And that's set out in 19 VSA 3018. And plaintiffs have conceded that point. They have said that the town could allow bicycle use, but through selective maintenance, they're attempting to usurp that power. And that's why I say that maintenance is being used as a proxy. And that's why this could not possibly have been the legislature's intent to allow this type of landowner veto power over who can use the trail. And to your point, Your Honor, that the width of the right of way is by default set in 19 VSA 775 at 3 rods, just under 50 feet. And that's the width of all the trails in this case. And the town can't go outside of that and allow bicycle use on adjacent areas. It has to stay within that right of way. But that's what we're talking about. We're talking about the right to maintain within the right of way granted by statute. And you know, the intensiveness of the use, you know, that is up to the town to decide in its power to regulate uses.
If I understand opposing counsel's argument correctly, there was a period of time, a lengthy period of time, where the town had the right to maintain trails, period. Then there was a period of time in the 70s and 80s where that went away. Now it's coming back, at least if I understand that the progression here correctly. So my question is, if I have that right, why would there be a period of time in this continuum where that authority did not exist? What's the explanation for taking it away and then bringing it back?
It's a great question, Your Honor. There is no explanation. It never went away, and the legislature would not have done that. As I understand plaintiff's argument, it is that from 1973 to 1986, the legislature broke down highways into 4 classes, class 1, 2, 3, 4. And part of this was to make it a little easier on towns to provide less maintenance, to have discretion to provide less maintenance on some of the lesser used roads. And they included trails within class 4 highways, and they applied the specific public good standard, which is a specific standard of discretion during that time period. 1986, they took trails out of that specific standard of discretion, but they did not prohibit maintenance. You know, that power existed before 1973 and afterward. And I think it's important to recognize that in the year that plaintiffs are claiming the legislature removed this authority, 1986, in the same bill, they added 2 very important provisions related to trails. For the first time, they defined trails as public rights of way. And they added the town's authority to promulgate regulations to govern the use of trails. Now, why would they do that if there was no power to repair them and maintain them to keep them safe and open for public use? The clearest indication of the legislature's intent is its use of the term public right of way. Now, this court, when interpreting statutes, looks at a legal term of art and imports its well-understood legal meaning. And a right of way, as you pointed out, Judge Chaffetz, has a long history of common law defining it, hundreds of years. And there are numerous authorities that we've cited to in our brief, pages 5 to 7 of the town's brief, pages 3 to 4 of the state's brief in this case, lay out these authorities. And the bottom line is that a public right of way is a right of way.
But if the legislature, as you said, was going to the trouble of making these changes in 1986 and adding these other important provisions, if it had wanted to preserve the town's authority or right to maintain the roads, why wouldn't it have said it explicitly? I mean, why didn't it do that?
You know, I can't answer exactly why the legislature did what it did. We're looking backwards, but from 1921 to 1973, there was no provision saying that towns had the right to maintain trails. And yet this authority was assumed when in 1973, when the legislature added this specific type of discretion, specific standard of discretion, there was no question that the towns already had the power to maintain trails. And just as when they took away that particular standard, that authority to maintain trails remained. There's no provision prohibiting maintenance, and the term of art that the legislature used, a public right of way, imports the right to maintain.
In your view, is a lack of responsibility for trail maintenance the same thing as a lack of authority for maintenance of trails?
They're not the same. No, Your Honor, in the provision that towns shall not be liable, synonymous with responsible, for maintenance of trails has existed since 1921, since trails were first recognized statutorily. And that provision has remained almost unchanged throughout all the years and remains today. And the obligation to maintain a trail is not the same as the authority to do so. As it exists right now, towns have essentially plenary discretion to maintain their trails, and they are totally immunized from any defects or problems with the maintenance that they provide. And that is the solution that the legislature came up with, perhaps, as has been suggested in briefing, to deal with lawsuits for injunctive relief against towns for discriminatorily applying the public good standard.
Mr. Codius, as you know, we follow here the Dillon's rule. And how does that affect your argument there in terms of the authority and the ability to maintain?
Yeah, Dillon's rule is really strongly in favor of the town's position here, to the extent that the court finds that the statutes are ambiguous. Looking to Dillon's rule, all of the provisions relating to trails in Title 19 would be meaningless without the ability to maintain and keep trails open. To that point, counsel at oral argument today has mentioned that towns do not have the power to construct new trails, which I believe is the first time that argument has been raised in briefing. And that is an extraordinary point, because 19 VSA 301 gives towns the explicit authority to lay out new trails. How could it be that a town could lay out a new trail and not construct it? This would set up a waste of municipal assets, and theoretically, towns could be subject to lawsuits for exercising any of the authorities that they have in Title 19 relating to trails, because it would be a waste of municipal assets. In Vermont, taxpayers have standing to bring lawsuits based on a waste of municipal assets, and towns could be subject to that liability. There's no way that the legislature would have set up that type of situation. Instead, it is fairly implied and necessary for towns to have that authority in order to carry out all the other powers that they have in Title 19. And I want to go back to the chronology of legislation for a moment. We were talking about 1986 when the legislature added a couple of provisions. And in 1991, the legislature added two more critical provisions to hammer home the notion that towns have authority over their trails and need to be able to keep them open. They expanded the definition of trails to allow for recreational use, and at the same time gave towns the authority to remove obstructions from trails and recover the cost of repairing the damage from those obstructions. Now, I think that is about as close to implying the authority to maintain and repair trails as you could possibly get without actually spelling that out. And that's why we think that Dillon's rule is such a strong argument in this case. I want to briefly address a constitutional argument that counsel made in plaintiff's brief, in that asking the court to interpret this statute in favor of private property rights because of the takings clause and because of the protections in Article 1 of Chapter 1 of the Vermont Constitution. The provisions addressing private property rights in the Constitution explicitly say that private property may be taken for a public use. And it is only under plaintiff's interpretation in this case that the town's trails would be put to a private use instead, because they would be subject to a landowner's veto power over maintenance, which would effectively allow them to control who can use and visit the trails. They also ignore the common benefits clause, which was addressed in VLCT's brief in this appeal. And this, effectively says that laws must be for the benefit of all the people and not for a particular person. And yet, if you follow plaintiff's interpretation of the statutes here, the trails in Tunbridge would be for the benefit of the servient landowners who can exercise control through selective maintenance over who gets to use the trail. The legislature could not have set up this type of situation with Title 19. They did not. And instead, they strongly implied the authority to maintain trails. At the end of the day, the legal trails are public assets. These are rights in property that the legislature has given to towns, and for them to have any value, for any of the town's powers with respect to trails to have any meaning, they have to be able to have the power to maintain and repair them. Thank you, Your Honors.
Okay, thank you very much. Does the appellant have time?
Appellant has 3 minutes and 20 seconds remaining.
Counsel, before you start, what's your position about the argument that's being made with respect to Title 19, 1105, and the 1991 expansion of town authority? What is your position with regard to that argument?
I'm not sure. I'd like an opportunity to respond to that. And I don't have a response now, and I apologize.
Well, you can supplement your argument, of course, if you want, after the hearing. File something with us.
Prior to 1986, towns had the right to maintain trails because they were included in the definition. In 1986, there was a change in the definition, and at that point, they no longer had the right to maintain public trails. It's not included in Class 4 anymore. They simply didn't have the right. And this discussion of the common law, I think, frankly, it doesn't apply in this case. There's a series of cases from this court, the Lang versus Kirkle, and a recent case, State versus Richards, which we did not cite in our papers, and I apologize. Those cases say that where the legislature has attempted to cover the entire subject matter, the common law doesn't apply. And whatever you may think of Title 19, it was an effort by the legislature to cover the entire subject matter of trails, of roads, the whole ball of wax. It is included within the statute. So any sort of common law alleged right or effect, we say it doesn't apply. You simply need to look at Title 19. And if the right does not exist within Title 19, the town does not have the right to maintain public trails. The legislature considered this issue in 1986. It made a decision that they were removing it, and the town after 1986 simply did not have the right to maintain public trails because the legislature decided that.
Well, I'll ask you the same question. If the legislature decided that, in other words, they were going to remove this really important right that the town had to maintain trails, wouldn't they have explicitly said that in the statute? Where does it say in the statute, towns may not repair trails?
Oh, when they changed the definition.
That's all they did is change the definition. How do you get from that to removing this very important right of the towns to maintain its public trails?
Well, I'm not sure it's a very important right, but the legislature indicated that class 4 roads were included, and then they changed the definition so that trails weren't included. I don't think the legislature has to say, and therefore we are directing that towns don't have this right. If it's not within the definition, they don't have the right, period.
Well, what if it's in the definition of a public right of way?
I think my time is up.
Well, you can finish your answer, please. Go ahead.
Again, a public right of way isn't defined to give them any particular rights. I mean, I just don't see that the use of that term. A public right of way is simply gives to somebody the right to be at a particular place to go over it, but it doesn't give them any particular common law right.
Your time is expired. Thank you. Please call a conclusion of the hearing.
That concludes today's hearings.
Thank you both.